that, and then now you're starting to stream. You guys are good.
All right, and then
that's going to open up a YouTube window on your side. So you're going to want to close that when your Chrome or Safari. Otherwise, you're going to get a crazy echo. And then as long as it says at the top, live on custom live streaming service, you guys are good.
All right. Yes,
Excellent.
It does.
Good luck, everyone.
Okay. All right,
Thanks.
I'm going to go now. Thank you.
And Tiago, I gave you my cell phone number, I think. So
Yeah, I actually texted you.
Oh, okay. Oh, there it is.
But it was about what you just explained. So
perfect.
not,
And if you need anything else, that's where you can find me.
Sure. Thanks.
Good luck, everybody.
Are we getting?
All right.
Are we getting our other judge?
Let's see.
Because we have. Laura said she was going to go get our other scoring judge.
Yeah. All right. So that's who we're waiting on. In the meantime, no conflicts.
No.
Oh, I think here comes our other judge. Nope.
And then once we start, you want us to turn off our camera and
Yeah,
mute
for the
ourselves.
scoring judges, yes.
Yeah, great.
I'm gonna step away for a minute. Is our other judge here? Yep. Oh, never mind. I'm asking because I haven't admitted him to the room. That looks like our last judge.
Yeah.
All right. So, Mr. Allard, is that right?
Yep.
I think everyone else has done conflicts checks. Can you just take a look real quick and make sure you don't have any reason why you can't be judging the folks that are in this room?
I think I'm good.
Okay. With that, are the prosecution and the defense ready to proceed?
The defense is ready to proceed, Your Honor.
Thanks. Sorry, I'm using two screens. It shouldn't be a problem in the future, but okay. Just to let you know, the instructions ask me to alert you that the Colorado Bar Association it says taking photographs. As you guys know, I assume this competition is being streamed. Is there anybody in here who's not competing in this round in the Zoom meeting? If so, now would be the time to leave. Just a quick reminder, there's not going to be any recesses unless there's a health emergency. We've already done our conflicts checks. A reminder that for teams and coaches that any dispute arising out of this competition has to be reported according to the competition rules. your compliance with the rules is part of your scoring. Let's see. All right, let's start with folks introducing themselves quickly, and I'll have the prosecution go first, introducing your participating members and your witnesses. And at this time, we can have the scoring judges turn off their cameras just for ease of interface. Thank you. Go ahead, prosecution.
Hi, my name is Naomi Kumar. I will be delivering the prosecution opening, directing Alex Aventis, and cross-examining Blake Van Owen.
Good morning. My name is Nia Weber. I will be directing Detective Jordan Markowitz, crossing Taylor Perkins, and delivering the closing argument.
Good morning. My name is Hannah Goldman. I'll be doing the direct examination of Kyle Kuzx and the cross-examination of Avery Becker.
My name is Lena Krinjic, and I'll be playing Kyle Kuzx.
Morning, my name is Emma Kester, and I'll be playing Jordan Markowitz.
Good morning, my name is Kylie Bannon, and I will be playing Alex Aventis.
Thank you. And defense?
Good evening, Your Honor, members of the jury, and opposing counsel. My name is Trevor Ferreira, and I will be delivering the opening statement on behalf of the defendant, as well as conducting the direct examination of Professor Blake Van Owen and the cross-examination of Alex Aventis.
Good morning. My name is Kyla Sabat, and I will be conducting the direct examination of Taylor Perkins and the cross-examination of Kyle Kuzx.
Good morning, my name is Noga Margalit. I will be conducting the direct examination of Avery Becker, the cross-examination of Jordan Markowitz, and delivering the closing statement on behalf of the defense. At this time, may our witnesses introduce themselves?
Yes, go ahead.
Good morning. My name is John Miley, and I am Avery Becker.
Good morning. My name is Felix Feiger, and I am Taylor Perkins.
Good morning. My name is Diego Smet, and I am Professor Blake Van Owen.
Okay, thank you, everybody. At this time, I will go ahead and swear everybody in. We're just going to do everybody at the same time. So you don't need to stand up, but raise your right arm. Team members, please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and the rules of the mock trial competition? And I'm seeing a lot of nodding. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, and that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Okay, and seeing more nodding. Okay, there should be nobody in the gallery other than the folks who are participating. And scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts and procedures and rules of the mock trial competition?
I do.
Alrighty, let's go ahead. All right, so if the prosecution is ready to begin with their case in chief.
Your Honor,
yes.
Before we begin, the defense does have some pre-trial motions or pre-trial matters to attend to.
Yes, go ahead. Actually, we'll start with the prosecution for pre-trial.
Of course.
Thank you, Your Honor. The prosecution has no pre-trial matters.
Okay. Defense?
Yes, Your Honor. First, the defense would like to request that attorneys and witnesses may remain seated during the entirety of the trial just to make it easier and so that everyone can hear everyone who's speaking.
Oh. And I'm sorry, before I go ahead, defense, what is your team code?
Oh, I'm sorry, Your Honor. We're Team Scooter.
Scooter?
Yeah.
And prosecution?
The prosecution is Team Kermit.
And apologize for the interruption. Go ahead, Counselor.
Yes, Your Honor. The defense would also like to request that in the event that a team member disconnects due to internet issues or any kind of medical emergency, that team member's teammates may reach out to them via text to see whether or not they may be able to rejoin the Zoom call or if a brief recess might be needed.
Yes, that's fine.
The defense would like to make it clear, though, that text messaging will only be used in the event that a team member disconnects. Otherwise, team members should be using the Zoom direct message feature in the chat function.
Yes, that's fine.
The defense would also like to request that as far as the admission of exhibits goes, an exhibit will be constructively screen shared by a council member to just the witness, and after the exhibit has been authenticated and published to the jury, then it is said to be constructively shared to the witness and the jury.
Yes. You still need to move to publish it to the jury, but all that logistical Zoom stuff, we will just handle constructively.
Yes, Your Honor. Finally, the defense would like to ask that pursuant to Rule 7.4, witnesses may annotate exhibits after they have been published to the jury using the Zoom annotation feature.
I'm sorry, can you repeat that?
Yes, Your Honor. The defense would like to request that after an exhibit has been admitted into evidence or published to the jury, that the witness may annotate on the exhibit using the Zoom annotation feature pursuant to Rule 7.4 in the mock trial rulebook.
Yes, that's fine.
The defense has no other preliminary matters to attend to, Your Honor.
All right. Let me just confirm one thing with Laura about our settings here. View, okay.
Hey, Tiago, it's Kyle again.
Yeah.
So quick, if you could go to the top right of your Zoom screen where it says view, click that and then just go to speaker view. And then that should solve all of our problems. Let's see what happens.
It was on speaker view.
No, I think it needs to be on gallery.
Oh, I'm sorry. Go to gallery view. My apologies.
Okay. Is that better?
Does that look good to everyone? Give a thumbs up from Trevor and Naomi if that looks good. Okay, I think we're good.
Okay.
And we'll be around if you need anything. Thanks, Tiago. You were good to get started.
Thanks for bearing with me.
No worries.
Okay. All right. With that out of the way, the prosecution, the floor is open for your case in chief. I am being asked for you to reintroduce yourself as you begin your examinations or your opening statement, as the case may be.
Thank you, Your Honor. My name is Naomi Kumar, and I will be delivering the prosecution opening. Ladies and gentlemen of the courtroom, a man is dead. Mr Brackman will never say hi to anyone, hug his family and friends, talk on the phone, worry about something, or enjoy life ever again. On March 6, 2020, late in the day, paramedics responded to a call from a passing motorist. This call led the paramedics to a gruesome murder scene in a neighborhood. Earlier that day, a man had been murdered in his own home. Mr Brackman was dead. A masked intruder with gloves on entered Brackman's house through the back door. Brackman and the intruder struggled through the house, leaving scuff marks on the ground. They went through the kitchen, leaving behind them a knocked-over dining room chair and a broken plate. Following a trail of blood droplets from the kitchen table, the struggle continued to the front door of the house, where Brackman was found dead in a large pool of his own blood that had slowly seeped out of the ragged knife wound in his back. The last light of Brackman's eyes left him just inside his own doorstep, inches away from escape. Today you will hear from dedicated mock trial senior Alex Aventis, who will detail how the defendant behaved in mock trial practice, as well as describe the series of escalating events that resulted from the challenging relationship between Avery and Brackman. Alex will also bring to light text messages that illustrate a strained relationship between Avery and Brackman, as well as an ominous message about a plan to take things one step further from vandalizing Brackman's car to damaging his house. You will also hear from Detective Jordan Markowitz, who was the first to respond to the scene and collect evidence. She will tell you about the broken plates, the chair that was knocked over, and the state of the victim's body when she found it. Detective Markowitz will also inform you of some critical cell phone tower evidence that shows where the defendant and her best friend, Taylor Perkins, were located the day of Mackenzie Brackman's death. Lastly, you will hear from crime scene investigator Kuzx, who has used a detailed process to go through the case. She will explain the events that happened at Brackman's house leading up to his murder. Kuzx believes that the intruder had a premeditated plan to break in. Today, the defense will introduce you to the defendant in this case, Avery Becker, another skilled mock trial lawyer who had nearly perfected the ability to make things up on the fly and construct a convincing argument with little to no prep. All Becker ever had to do was smile at each judge, and they understood that they knew the case. The defense will also introduce Becker's best friend, Taylor Perkins, who would do anything for Becker and even quit the mock trial team when she was demoted. The defense will also heavily rely on the perspective of Blake Van Owen, who is motivated by faulty personal relationships with both Detective Markowitz and crime scene investigator Kuzx. As you go through this trial, you will hear that Van Owen is a private investigator and has only ever in his whole time as a private investigator been hired for the role of defense witness. He is paid between $6,000 and $10,000 per case that he testifies for the defense in, and he takes on about 9 to 12 of these cases a year. Despite the defendant's constant and repetitive detrimental actions, they have never had to face the repercussions of these actions before. But here today, ladies and gentlemen, you have the opportunity and the responsibility to finally and permanently hold Avery Becker accountable for their actions. Mackenzie Brackman was a criminal defense lawyer and the hardworking and dedicated mock trial coach at Colorado High School. Brackman's passion and care for mock trial and his students should not be allowed to be minimized by the personal opinions and feelings of others. Mackenzie Brackman taught others the skills required to achieve their dreams and motivated others to pursue their passions. Ladies and gentlemen, today we will bring justice for a dedicated coach and attorney. The defendant, Avery Becker, is responsible for creating a world without Mackenzie Brackman, and he must be held accountable. Thank you.
Thank you, Counselor. Opening for the defense.
Yes, Your Honor. And once again, before I begin, my name is Trevor Ferreira, and I will be delivering the opening on behalf of the defendant. Unanswered, unpursued, unreliable. The evidence will show that the prosecution's theory for this case is filled with unanswered questions, unpursued evidence, and unreliable conclusions. Law enforcement failed to conduct a thorough investigation. They convicted the only suspect they ever looked at, and ultimately, Avery Becker has been wrongfully put on trial as a result. Today's case is a murder trial for the tragic death of Mackenzie Brackman. The defense is here today, and an innocent teenager is acquitted, and that true justice can be found for the decedent, Mackenzie Brackman. The evidence will show that Avery Becker was never present at Mackenzie Brackman's home on March 6th. Him and his best friend, Taylor Perkins, were with each other all day looking for Mr. Becker's lost phone. You'll learn that despite this fact, law enforcement isolated Avery Becker as their only suspect early on in their investigation. From there, you'll see how they failed to investigate other suspects, only interviewed one witness, and conducted a rushed and unsound investigation. Finally, you will learn that once they decided their limited evidence was enough, they wrongfully convicted Avery Becker of first-degree murder and second-degree burglary on the basis of misinterpretation, unsupported conclusions, and deliberate omission. My name is Trevor Ferreira, and I, along with my co-counsel, Noga Margalit and Alex Aventis, represent the defendant, Avery Becker. Today, the prosecution has a burden of proof that they won't be able to meet. The evidence that law enforcement gathered will not be able to claim and prove their incomplete story. Avery Becker was never present at Mackenzie Brackman's home. Oh, it appears my camera is frozen. I apologize. Avery Becker was never present at Mackenzie Brackman's home. Law enforcement's investigation was rushed and unsound, and ultimately, Avery Becker has been wrongfully accused as a result. In today's case, you will hear from 6 different witnesses. First, you will hear from the prosecution. The prosecution will call Detective Jordan Markowitz to the stand. Detective Markowitz will attempt to argue that Avery Becker was present at Mackenzie Brackman's home on March 6th. But pay close attention when you learn how she does this with incomplete locational evidence and how she only interviewed one witness during the entirety of her investigation. The prosecution will also call Kuzx to the stand. Ms. Kuzx will attempt to convince you that Mackenzie Brackman was killed in the midst of a struggle in his own home. But pay close attention when you learn how she does this with limited physical evidence and how she failed to consider alternative reconstruction to the crime scene. The prosecution will also call Alex Aventis to the stand. Ms. Aventis will attempt to convince you of text messages that were allegedly sent to her by the defendant, Avery Becker. But pay close attention when you learn how no detective ever confirmed whether or not these messages were sent, and how even though she received them in advance, she waited until after Mr. Brackman had died to tell him. You will also hear from the defense's witnesses. The defendant himself, Avery Becker, will come to the stand. Avery Becker will explain to you how all he wanted after getting kicked off the mock trial team was to be let back on. He would have never done anything to hurt Mackenzie Brackman, and he was with his best friend Taylor Perkins all day on March 6th. Next, you will hear from Avery Becker's best friend, Taylor Perkins. Mr. Perkins will once again explain to you how him and the defendant were with each other all day on March 6th, looking for Mr. Becker's lost son. Mr. Perkins will testify that because he was with him all day, Avery Becker could not have committed this crime. Finally, the defense will call private investigator and Professor Blake Van Owen to the stand. Professor Van Owen will explain how law enforcement misinterpreted crucial evidence, jumped to conclusions, and failed to investigate all the potential leads in their case. Professor Van Owen will explain the significance of law enforcement's omissions and how they failed to do a proper job when it mattered most. Unanswered, unpursued, unreliable. The prosecution must prove to you, ladies and gentlemen of the jury, that Avery Becker is guilty of first-degree murder and burglary beyond a reasonable doubt. The evidence that law enforcement gathered will be incapable of doing so. Avery Becker was never present at Mackenzie Brackman's home. Law enforcement's investigation was rushed and unsound, and Avery Becker has been wrongfully put on trial as a result. For these reasons, at the end of the trial today, the defense will ask for you to acquit Avery Becker, to not believe in law enforcement's incomplete story, and to ensure that true justice can be found for Mackenzie Brackman. Declare the defendant not guilty. Thank you.
Thank you, Counselor. Is the prosecution ready with its first witness?
Yes, Your Honor. The prosecution would like to call Alex Aventis to stand.
Go ahead, Counselor, whenever you're ready.
Thank you. And just to reintroduce myself, I'm Naomi, and I'll be directing Alex. Alex, please state your full name for the court.
My name is Alex Aventis.
Where do you go to school?
I go to school at Colorado High School.
And what extracurriculars are you involved in?
I was involved in the mock trial team.
Who else were members of your mock trial team?
Well, there was many, but two specifics are Avery Becker and Taylor Perkins.
How did you get involved with this mock trial team?
Well, Avery was actually the one who convinced me to try out for it when I was a freshman.
Do you see the defendant, Avery Becker, in this courtroom?
Yes, I do.
Can you please point him out to us?
Yes, he's right over there.
Thank you. Your Honor, can we please have the record reflect that the witness has identified the defendant?
The record shall so reflect, subject to cross-examination.
Thank you, Your Honor. Alex, who was your mock trial team's coach?
Mr Brackman was our amazing mock trial coach.
And how dedicated were you in your role as mock trial team member?
Well, I was very dedicated and I took my role extremely seriously.
Were there any rumors that you and Avery are rivals?
Yes, there were.
How valid are these rumors?
They were not valid at all, and I wholeheartedly disagree with them.
Was Avery timely on his arrival to mock trial practice?
No, he was constantly late.
Was Avery prepared for practices and tournaments?
No, he never came prepared for practices or tournaments either.
What was Avery's go-to tactic during practice?
Improvising and making things up on the fly.
And what would happen when Avery showed up late and unprepared?
Well, our coach, Mr. Brackman, usually put up with it, but I could tell that he was frustrated with Avery and he was always telling him to do better.
How did Avery react to Mr. Brackman telling them this?
Avery hated him because he was always telling him to do this.
What was your experience participating in mock trial with Avery?
Well, I didn't really appreciate the way that Avery treated our teammates or Mr. Brackman.
How did Mr. Brackman run mock trial practices?
He was always finding ways to improve the team, and he was always telling Avery to be better about utilizing proper preparation and hard work.
And what was Avery's reaction when Mr. Brackman told him this?
Avery simply refused, and he hated Mr. Brackman for it.
What did Mr. Brackman do when Avery arrived late to practice?
Yeah, so one practice after Avery arrived late for, I don't even know what time it was, Mr. Brackman and Avery reached a boiling point in their relationship.
What happened after that?
Mr. Brackman actually demoted Avery to the B team, and somehow Avery convinced Taylor Perkins to quit the team as well.
And what was the result of Perkins quitting the team?
Well, Mr. B was forced to let Avery back on the A team.
What awards did Avery win from being on the mock trial team?
He won the Best Attorney Award and the Best Closing Argument Award.
What happened in practice after Avery won those awards?
Well, Mr. Brackman confronted Avery and told him that even though he won the awards,
Objection, Your Honor. This is hearsay.
Response.
Your Honor, this question goes to show that this question is Alex telling what happened after the practice, which Alex was at as well. So, yeah.
Your Honor, may I respond?
Go ahead.
Mr. Fuentes here is testifying as to what Mr. Brackman told Avery Becker after Avery Becker won these two awards. And while I do not oppose to Alex Fuentes talking about what she personally observed, this is a statement of hearsay on behalf of Mr. Brackman, and therefore it is inadmissible in court today.
Yeah, Ms. Kumar, I'm not hearing why this either isn't hearsay or is admissible hearsay, so I'll give you another chance to explain why it should be admitted before moving on.
I'll just move on, Your Honor. Thank you.
Okay, so the objection is sustained and the question is stricken.
Okay, Alex. What did you observe as that practice ended that day?
Well, Avery, after he was leaving practice, he was so upset that he purposely decided to vandalize Mr. Brackman's car.
Proper foundation has not been laid that Avery Becker had reason to be upset at this practice.
Response.
Your Honor, the witness just testified that Avery and Brackman just had an argument during the practice.
I agree. Overruled.
Thank you, Your Honor. Alex, I'll restate the question. What did you observe Avery did as he was leaving the practice that day?
Well, as he was leaving the practice, he was so upset that he purposely decided to vandalize Mr. Brackman's car by writing Worst Attorney Award on the hood in permanent marker.
Where did Avery get the permanent marker from?
He grabbed it on his way out of practice.
And what were the consequences? Oh, sorry, witness, keep going.
Sorry. Yeah, he grabbed it from the easel of paper that was used to write our trial ideas, but that was nowhere near any other markers.
And did Mr. Brackman ever press charges against Avery?
No, but he should have. Avery clearly knew what he was doing.
How did
Objection, Your Honor. Mr. Fuentes does not have the ability to testify Avery Becker's mental state while committing these actions. While I do not oppose to Mr. Fuentes testifying to what she saw when this happened, I do oppose to her testifying to what Avery Becker was emotionally feeling and the intentions or motives that Avery Becker had while doing these actions.
Before I hear your reply, Ms. Kumar, Mr. Ferreira, going forward, if you could refrain from making speaking objections, just let me know if you're objecting to speculation, hearsay, and then we can go from there. So, Ms. Kumar, what's your response?
I will happily rephrase the question, Your Honor.
Okay, so the objection will be sustained.
Alex, I'm gonna move on. How did Avery seek help after they vandalized Mr. Brackman's car?
He actually texted me.
Alex, I'm handing you what has been marked as Exhibit 14. Do you recognize Exhibit 14?
Yes, I do.
What is Exhibit 14?
Exhibit 14 is the text messages between me and Alex.
How do you know this?
Well, because I was involved in this conversation.
And is Exhibit 14 a true and accurate representation of the text messages between Avery and you as you received it?
Yes.
Your Honor, I would move to admit Exhibit 14 into evidence.
Mr. Ferreira, any objection?
No objections, Your Honor.
Then Exhibit 14 will be admitted.
Your Honor, I also move to publish Exhibit 14.
Exhibit 14 will be constructively published to the jury, and I will just, if you could give me the page number.
Of course. It is page 70 and 71.
Okay, and it's also being shared on the screen.
Yes.
Thank you. Go ahead, Counselor.
Thank you, Your Honor. Alex, who is texting in the gray colored text bubble?
Avery is.
And who is texting in the green colored text bubble?
I am.
Who is the person that texts, well, if he's still going to be upset about his car, he's going to be really upset when he sees what I'm going to do to his house?
Avery texted this.
In these texts, did Avery ask you for help?
Yeah, he asked that I speak with Mr. Brackman and ask him to let Avery back on the team.
What did you do after Avery texted you and asked you for help?
Well, I spoke with Mr. Brackman and I asked him to let Avery back on the team for the sake of the rest of my teammates.
And what did you tell Avery after that?
Well, I texted him back and I told him that Mr. Brackman was not going to back down and let him back on the team.
What did Avery text you back?
Avery became enraged and he texted that if Brackman thinks that he was upset about what happened to his car, then wait until he sees what he does to his house.
Thank you, Your Honor. No more questions.
Cross-examination?
Yes, Your Honor. Good morning, Mr. Fuentes. I'd like to start by talking to you more about your time on the mock trial team. You and Avery Becker were on the mock trial team together.
Yes.
You would say the two of you were basically best friends.
We were friends.
You always prepared very well for mock trial.
Yes.
Avery Becker, in comparison, would often show up late.
Yeah.
As you mentioned, this caused Avery Becker to get demoted from the A team to the B team.
Correct.
You were excited for the larger role you would have with Avery Becker off the A team.
I guess.
So that's a yes. You were excited for the larger role you would have with Avery Becker off the A team.
Yes.
Further, you thought the mock trial team was better off without Avery Becker.
Well, yeah, just because of the fact that he was not kind to all of us and he was constantly late.
Mr. Fuentes, I'd now like to talk more about your role in this case. You believe Mr. Becker planned on going to Mackenzie Brackman's home.
Yes.
You believe this because of some alleged text messages.
They're not alleged. They were the text messages that I received from Avery.
So that's a yes. You believe this because of some text messages.
Yes.
Mr. Fuentes, I want to take a closer look at these messages. Co-counsel, could you please screen share Exhibit 14?
I'm sorry, 1 second. I'm having issues with the Zoom. My apologies, Your Honor.
No problem. I'm sure we will all have them. I've already had them.
Your Honor, if you will allow it, I would also be fine screen sharing the exhibit myself if that might be easier.
That's fine with me.
Okay. Oh. Mr. Fuentes, this is the text conversation that convinced you Mr. Becker had plans to go on to Mackenzie Brackman's house.
Yes.
You would agree that none of these messages have any timestamps on them?
No, because they could have got cut off when I screenshotted them.
So that's a yes, you would agree there are no timestamps?
Correct.
You would agree that there's also no date on this screenshot?
Again, they could have got cut off, but yes.
The conversation allegedly began with Mr. Becker asking for your help to get back on the mock trial team.
Yes.
Somewhere in this alleged conversation, Mr. Becker told you that he planned on going to Mackenzie Brackman's house.
Correct.
Thank you, co-counsel. You may stop screen sharing the exhibit. I want to create a timeline for these messages and what you did with them. This conversation allegedly began shortly after Mr. Becker was kicked off the mock trial team for good.
Yes.
As you mentioned on direct, you believe Coach Frackman should have pressed criminal charges on Avery Becker after he vandalized the coach's car.
Correct.
Yet, when Mr. Becker allegedly tells you that he's going to break into Mackenzie Brackman's home, you don't immediately tell Mackenzie Brackman, do you?
I didn't know anything for sure, so no.
You didn't immediately tell the police either.
Again, I didn't know for sure. But
So
no.
that's a no.
Correct.
You didn't tell either the police or Mackenzie Brackman at any point between receiving these alleged messages and Mackenzie Brackman dying.
No, because again, I really did not know for sure.
Finally, you received word that Mackenzie Brackman had died. You still did not immediately show these alleged messages to the police.
No.
Finally, the police called you, and that's when you told them about these alleged messages.
Yes.
The police asked you to come down to do a full interview because of these alleged messages.
Yep.
You knew the police wanted to see these alleged messages, but you didn't bring your phone to that interview.
I just forgot it. I was really nervous that day, and when my dad yelled at me to come down, I just forgot my phone, and it was charging upstairs.
Mr. Fuentes, you don't need to justify why you didn't bring it. So that's a no, you did not bring your phone to that interview.
No, I did not.
The detective was fine never seeing your phone.
Yeah, he just wanted me to send him some screenshots of it.
That detective even turned down your offer to come back with the phone.
Yep.
All that detective ever got to see of these alleged messages were the screenshots that you sent them.
Yes.
Thank you, Mr. Fuentes. Your Honor, no further questions at this time.
Ms. Kumar, any redirect?
I do have a brief redirect, Your Honor.
Go ahead.
Thank you. Alex, what was your relationship with Mr. Brackman?
Well, he was my amazing coach.
Thank you. That's all, Your Honor.
And Oh, we won't be allowing recross on that redirect. Prosecution, you may call your next witness.
Thank you, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand. Once again, to reintroduce myself, my name is Mia Weber. Can you please identify yourself for the record?
My name is Jordan Markowitz.
What's your occupation?
I am a homicide detective.
How long have you been a homicide detective?
For 7 years, and I've been with the Denver Police Department for 13 years.
Can you please describe your relationship to the case Colorado versus Avery Becker?
I was the detective assigned to investigate the death of Mr. Mackenzie Brackman.
What led to you becoming involved in this investigation?
A motorist reported seeing a person passed out on the porch of Brackman's house. After paramedics responded and called for police, officers secured the scene, and I arrived at 14:20 hours.
Thank you. I'm going to move on and address some of your observations upon your arrival at the scene. Detective Markowitz, I'm referring you to what have been labeled as Exhibits 1, 9, and 3. Do you recognize these exhibits?
Yes.
What are these exhibits?
Exhibit 1 is a photo of Brackman's house and the victim's body as visible from the porch. You can also see the Ring doorbell. Exhibit 9 is a photograph of the dining room where you can see a broken plate on the ground. What was the third exhibit?
Exhibit 3.
Thank you. Exhibit 3 is a close-up photograph of the victim's back where the stab wound is visible.
How do you recognize these exhibits?
I know this because I was at the scene and I saw all of the articles and items that were photographed in these exhibits.
Are Exhibits 1, 9, and 3 a true and accurate representation of the scene as it appeared on March 6, 2020?
Yes, they are.
Your Honor, I move to admit Exhibits 1, 9, and 3 into evidence.
Okay, let's go one by one here.
Absolutely.
Miss Marguerite, am I saying your last name correctly?
Yes, Your Honor.
Pardon?
Yes, Your Honor, that's correct.
Miss Marguerite, do you have any objection to the admission of Exhibit 1?
No objections, Your Honor.
Any objection to the admission of Exhibit 9?
No objections, Your Honor.
And the other one was Exhibit 3?
Yes.
Any objection to Exhibit 3?
No objections, Your Honor.
Okay, Exhibits 1, 9, and 3 will be admitted.
Thank you, Your Honor. Permission to publish these exhibits?
Granted.
Thank you. If co-counsel will be kind enough to share Exhibit 1. Detective Markowitz, what can you summarize from Exhibit 1?
In Exhibit 1, there was the victim's body as visible from the porch. The front door was left wide open, and there was a Ring doorbell set up.
Thank you, Detective Markowitz. When you entered the household, what did you observe?
The residence was in complete disarray. The kitchen had a partially open kitchen drawer with several knives in it. In addition, I noticed that there was a knife block on the counter with an open slot for a large knife.
After you made observations in the kitchen, where'd you go?
I went to the dining room.
If co-counsel could please share Exhibit 9. Detective Markowitz, what stood out about the state of the dining room?
As you can see in Exhibit 9, there was a chair knocked over and a broken plate on the...
Under Rule 702, this witness is giving expert testimony when they are not entered as an expert.
Response.
Your Honor, this witness is not making any conclusions or any expert summarizations of what's happening. The witness is simply testifying to what they saw on this day, which is, in this case, a broken plate on the floor.
Can a witness repeat the answer?
Yes, Your Honor.
And we would be doing this outside the presence of the jury.
As I was saying, there was a chair knocked over and a broken plate on the ground.
Okay. Insofar as that was the answer given, the objection will be overruled, but if it goes much further, Ms. Marguerite, you can renew your objection.
Yes, Your Honor.
Thank you. Detective Markowitz, I'll re-ask the question. What stood out to you about the state of the dining room?
As you can see in Exhibit 9, there was a chair knocked over and a broken plate on the ground. And this is not included in Exhibit 9, but I also noticed in the surrounding area, there were several drops of blood on the floor.
Thank you. Detective Markowitz, after you observed the dining room, What did you see?
I saw the open door and the knife on the floor. The victim was face down in a pool of his own blood, and there was also blood around the stab wound and on the floor around the victim.
If co-counsel could please share Exhibit 3. Detective Markowitz, what did you observe upon finding the victim?
There was a large knife near the victim. His shirt was blood-soaked around the upper left back and shoulder area.
Thank you, Detective Markowitz. After discovering the victim, where did you go?
I went to look throughout the rest of the home.
What did you observe upon looking throughout the rest of the house?
Well, I observed that there were no other victims and expensive items like laptops and flat-screen TVs were left undisturbed.
Detective Markowitz, how did you discover Mr. Brackman's ties to the Colorado High School mock trial team?
When I downloaded the contents of Brackman's phone, I found texts and emails related to mock trial. In addition, he was wearing a shirt related to mock trial.
Who did you speak through following this breakthrough?
I contacted the members of the mock trial team, and the first student I spoke with was named Alex Aventis.
What information did you gain from speaking with Aventis?
Alex told me about another student who had texted about a plan to trash Brackman's house.
Hearsay under Rule 805.
Response?
Your Honor, under Rule 801D, this is prior consistent statement. It's admissible as Alex Aventis has already testified under oath and provided the basis of this information in Exhibit 14.
And you said 801D?
Yes, Your Honor.
Any response, Ms. Margoley?
Yes, Your Honor, this is hearsay within hearsay. This is the statement Alex Aventis made during interviews to Ms. Markowitz, and then within that is the statements of Avery Becker to Alex Aventis, and the prosecution will be using these statements, so they are hearsay within hearsay.
Not sure about the hearsay within hearsay, but I'm not inclined to find that this fits under 801D. So is there some other reason why the court should admit this statement, Ms. Weber?
Simply that Alex Aventis previously testified to this, and Detective Markowitz is simply corroborating his statement.
But why would it not be hearsay? What I'm
not-
ruling is that 801D does not apply here because it's not. I'm ruling that 801D does not apply here.
Okay, Your Honor, I'll move on then.
Okay, so the objection, the original objection as to hearsay will be sustained.
Permission to strike the witness's response.
And the response will be stricken.
Detective Markowitz, did you speak directly with Alex Aventis?
Yes, Alex Aventis conducted a full interview where he talked about the difficult relationship between the victim and the defendant.
Hearsay.
Response?
Your Honor, Alex Aventis has already testified about the difficult relationship, and this is simply Detective Markowitz talking about what occurred during this interview and what he took away from their conversation.
And with the, I think it's being offered for the effect that it had on the detective's investigation, so I will overrule.
Thank you, Your Honor. Detective Markowitz, I'll ask you the question once again. Did you speak directly with Alex?
Yes, Alex Aventis went into the police department where he conducted a full interview, where I learned about the difficult relationship between the victim and the defendant, as well as how Alex had learned about Avery's plan to burglarize and vandalize the victim's home.
Thank you. I want to move on and talk about some of the cell phone evidence in this case. Detective Markowitz, can you please describe what experience you have working with cell phones?
Yes, I have specialized training and experience with cell phones. I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement. This taught me about how to differentiate the types of cell phone data and records that can be obtained, how to use forensic software such as the Cellbrite system, how to inquire and interpret cellular records, and how to obtain and interpret call tower data.
I would like to ask the court to designate Detective Jordan Markowitz as an expert in cell phone evidence and call detail records pursuant to Rule 702 of the Colorado Rules of Evidence.
Okay, give me 1 second. Can you repeat the tender? What area?
Yes, Your Honor. An expert in cell phone evidence and call detail records.
Any objection from the defense?
A brief voir dire, Your Honor.
Yes, we will go ahead with a brief voir dire. Go ahead, Miss Marguerite.
Yes, Your Honor. Good morning, Ms. Markowitz. I'd like to begin by discussing your work with cell phones. You state no previous education with cell phone technology.
I do have a certification, so I do have a type of education in this.
Let's talk more about that certification. You received that certification after a 3-day training.
And a certification test, yes.
Which took place within your 3-day training.
I believe so.
Thank you. Your Honor, at this time, we do not accept Ms. Markowitz as an expert in cell phone data analysis. For her entire experience revolves around a limited training. She does not have the proper education, skill, knowledge, or experience to testify about this under Rule 702.
And response from Ms. Weber?
Yes, Your Honor. Detective Markowitz has extensive knowledge through training and experience that the average person does not have. Detective Markowitz has used this experience and training constantly, has downloaded the contents off of hundreds of cell phones, and he uses cell phone tower data on a regular basis and has obtained and interpreted cell tower data in over 50 cases.
The court will admit Detective Markowitz as an expert in cell phone evidence and call detail records, and the objection to the tender will be noted for the record, but overruled.
Detective Markowitz, did you examine cell phone records in this case?
I did. I examined the victim's phone and pulled various records relating to the defendant's phone.
How did you gain access to these records?
I obtained a warrant for the defendants and I directly downloaded the information from the victims.
What type of records did you examine?
I got access to cell tower records from Avery's phone for March 6, 2020. I also received call detail records.
What did you learn from the call detail records?
In this case, the call detail records showed that another cell phone was sending several texts and calls to Becker's phone leading up to Brackman's death.
Detective Markowitz, I'm referring you to what has been marked as Exhibit 16. Do you recognize Exhibit 16?
Yes.
What is Exhibit 16?
This is a diagram that shows the route the defendant most likely drove based on call detail records.
How do you know this?
I know this because I was the one who put this diagram together.
Detective Markowitz, is Exhibit 16 a true and accurate representation of what the call detail records from the defendant's phone tell you about the route the defendant drove?
Yes, it is.
Your Honor, I move to admit Exhibit 16 into evidence.
Any objection?
No objection, Your Honor.
Then the exhibit will be so admitted.
Thank you, Your Honor. I move to publish Exhibit 16.
Go ahead.
Thank you. If co-counsel could please share Exhibit 16. Detective Markowitz, can you please explain to everyone what Exhibit 16 depicts?
Exhibit 16 depicts the 3 cell phone towers that the victim's phone pinged with before and during and after the murder of Mackenzie Brackman, as well as the estimated route I presume he took based off of this information.
Thank you, Detective Markowitz. I have no further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Good morning, Ms. Markowitz. I'd like to begin by discussing your methods for finding evidence. You would agree it's important to follow up on all possible leads.
Yes.
Let's discuss the leads you followed up on. Your first interview was with Alex Aventis.
That is correct.
You didn't interview Taylor Perkins.
No, I did not because he decided to side with the defense.
Regardless, you did not interview Taylor Perkins?
No, I did not.
You didn't interview the defendant?
I attempted to contact the defendant, but his lawyer refused to come in for an interview.
So is that a yes, you did not interview the defendant?
Yes, I couldn't.
Now, you also didn't interview anyone else on the mock trial team?
No, I did not.
Now, I'd like to discuss more of the leads
You didn't interview anyone else except for Alex Aventis.
Yes, that's how it turned out.
Now I'd like to discuss more of the leads you didn't follow up on. It is your opinion that it is highly unlikely that Mr. Brackman's mock trial activity had anything to do with his death.
That was my initial thought until I got more evidence.
But that was your initial thought, correct?
Yes.
It is also your opinion that the fact that Mr. Brackman was a criminal defense lawyer raised the specter that this could be the work of a disgruntled ex-client.
It seemed unlikely, but that was a possibility I considered.
It also looked to you like this was a random burglary that Mr. Brackman had interrupted.
Yes.
But since you got that first interview, you didn't follow up on any of these possibilities.
I considered them, but I had no evidence to support them.
Now, I'd like to talk about the one lead you did follow up on. You interviewed Alex Aventis, who showed you these supposed texts from Mr. Becker.
Yes, I did.
Ms. Aventis did not have her phone on her when you interviewed her, correct?
No, I assumed she was stressed and forgot it at home.
I'm not asking why she forgot her phone. I'm asking if she forgot her phone. Is that a yes?
Yes, that is.
Thank you. Now, Ms. Aventis only sent you screenshots of these supposed texts the next day.
Yes.
You also discussed how you gathered call detail records for Avery Becker's phone.
Correct.
And these records indicate whether certain calls or texts were made to a phone.
Yes.
But you didn't gather any of this information for Alex Aventis' phone.
No, I did not.
Now, I'd like to move on and discuss the physical evidence you found. You are not an expert in blood spatter, correct?
No, I'm not.
You also have no formal education in being a homicide detective.
No, just years of experience.
You also have no formal education as a crime scene investigator.
No, I do not.
And you also lost photos taken at the crime scene.
I believe the photos were corrupted, but I was not in charge of that.
And these were photos of blood spatter.
Yes, they were.
And so now no other expert can review these photos.
No, but there is another witness who saw the blood spatters as I did.
But no other expert can review these photos, correct?
Correct.
Now, finally, I'd like to discuss your findings with the cell phones. You created a map of this case.
Yes, I did.
If my co-counsel could now share Exhibit 16, which has been previously entered. Now, on this map, you chose to put 3 cell towers.
Yes, because they were the ones involved prominently with the case.
Yes, and you also chose to put 3 different houses on this map.
Yes.
You chose to put Mr. Brackman's house.
Yes.
And you chose to put Mr. Becker's house.
Yes.
You also chose to put Blair Rollins' house on this map.
Yes.
A map which you say you decided to put things on that were prominent for this case.
That is correct.
Thank you, Your Honor. I have no further questions at this time.
Any redirect, Ms. Weber?
No redirect at this time, Your Honor.
Okay. Does the prosecution have any further witnesses?
Yes, Your Honor. The prosecution would like to call Kyle Kuzx up to the witness stand.
Your witness, counsel.
Kyle Kuzx.
Oh, I'm sorry. I was saying go ahead when you're ready.
Oh, thank you, Your Honor. Ms. Kuzx, could you please introduce yourself to the court?
My name is Kyle Kuzx.
Where do you work?
The Denver Police Department.
What is your position at the Denver Police Department?
I'm a crime scene reconstruction investigator.
And how long have you been a crime scene reconstruction investigator?
For 19 years.
And in your 19 years of experience, what kind of crime scenes have you investigated?
Home invasions, fatal accidents, domestic violence, homicides, and burglaries.
Your Honor, I would like to ask the court to designate Ms. Kuzx as an expert in crime scene reconstruction pursuant to Rule 702 of Colorado Rules of Evidence.
Any objection or voir dire?
A brief voir dire, Your Honor.
And can I get the tender again? What is the field?
In crime scene reconstruction, Your Honor.
Crime scene reconstruction.
Your Honor, before I begin, may I please have a quick time check?
Okay. How are we doing on time?
There are 9 minutes and 1 second left for cross-examination.
Thank you very much. Now, Ms. Kuzx, you are not a police officer, correct?
No, I'm not, but I have 19 years of experience.
You have no training in police procedure, correct?
No, I do not.
You do not conduct any investigations into possible motives or suspects, do you?
I do, because I'm a crime scene reconstruction investigator.
Ms. Kuzx, your work involves examining the physical evidence at the scene of the crime, correct? You do not conduct witness interviews or look into possible motives, correct?
No, but based on the evidence at the scene, I make a hypothesis.
Yes, thank you very much. Your Honor, at this time, we do not object to Ms. Kuzx being entered as an expert in crime scene reconstruction, but we would like to limit the scope of her testimony to only the evidence found at the scene of the crime, as that is the only evidence needed to reconstruct the crime.
A brief response?
Yes, Your Honor. According to Rule 702 of Colorado Rules of Evidence, which is lenient standard, knowledge through training or experience that the average person does not have, Ms. Kuzx has spent 19 years of her career reconstructing and investigating crime scenes and is qualified to testify with her knowledge and expertise to the events leading up to Mr. Brackman's death. Ms. Kuzx has investigated complex crime scenes, including home invasions, burglaries, other property crimes, homicides, domestic violence, fatal accidents, and armed robberies.
And Ms. Goldman, what do you say about limiting the testimony, limiting the scope? So the court agrees, and the parties seem to agree that this witness can be an expert in crime scene reconstruction. On the limited issue of whether this person can testify beyond what's specifically necessary to reconstruct the scene, what's your response to that?
Yes, the intention of this direct examination, Ms. Kuzx was not going to be discussing police practices or the investigation of other witnesses.
Okay, so I will at this time just note the objection for the record. I'm not going to limit the testimony prospectively. So, Ms. Abbott, you will have to raise those objections as they occur, but the court is on notice.
Thank you, Your Honor. Ms. Kuzx, when did you visit the crime scene?
I visited the crime scene after it was processed by other members of the crime lab.
What documents did you review regarding the case prior to reconstructing the crime scene?
Police reports relating to the case, photographs, and the ring security cameras.
What is your methodology to ensure an accurate and efficient flow of your work as a crime scene reconstruction investigator?
Well, I have 5 steps: recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and finally, reconstruction.
Did you view the digital files for the photographs of the crime scene?
Yes, I did. I reviewed them before they became corrupted.
Did you also analyze the ring videos to help reconstruct the crime scene?
Yes, I did.
CSI Kuzx, I'm referring to what has been labeled as People's Exhibit 12 on page 69.
Okay.
What is People's Exhibit 12?
That is the intruder entering the back door of Mr. Brackman's residence.
Do you recognize it?
Yes, I do.
How do you recognize it?
As I mentioned before, I reviewed all the ring security camera footage.
Is it a fair and accurate copy of the video which shows the intruder entering Mr. Brackman's house as you saw it?
Yes, it is.
Your Honor, I would like to move to admit People's Exhibit 12.
Any objection, Ms. Abbott?
No objection, Your Honor.
Then Exhibit 12 will be admitted.
Your Honor, I would like to also publish Exhibit 12.
Yes, go ahead.
If my co-counsel would be kind enough to screen share Exhibit 12 now.
Apologies. I'm having technical difficulties screen share.
Ms. Goldman, I can screen share Exhibit 12.
Thank you, Ms. Weber. That would be great.
Pardon me, give me one moment. I may not be able to. My settings seem to be disabled. Thank you.
Thank you, co-counsel. Ms. Kuzak, in this video, which part of the house was the intruder entering?
The back door.
Could you please describe the intruder?
The intruder was wearing a Halloween mask and gloves.
What conclusions can you draw from this as a crime scene reconstruction expert?
Well, it shows me that this may have been premeditated because he had no hesitation entering that back door.
Have you had a chance to observe the defendant in this case?
Yes, I have.
How does the defendant compare to the intruder?
The defendant matches the general height and build of the intruder.
Objection, Your Honor. This is outside the scope of Ms. Kuzak's expertise.
Response?
It's okay, Your Honor. I'll move on right now. Ms. Kuzak, were you able to find any DNA evidence?
No, because the intruder was wearing gloves, so no fingerprints or anything like that.
CSI Kuzak, I'm now referring to what has been labeled as People's Exhibit 18 on page 78.
Mm-hmm.
What is People's Exhibit 18?
Those are the scuff marks.
Do you recognize People's Exhibit 18?
I do.
How do you recognize it?
Because I was at the crime scene.
Would you say that People's Exhibit 18 is a fair and accurate reflection of the scuff marks as you investigated it?
Yes.
Your Honor, I would like to move to admit People's Exhibit 18.
Any objection?
No objection, Your Honor.
Exhibit 18 will be admitted.
Your Honor, I would also like to publish Exhibit 18.
Go ahead.
If my co-counsel, thank you. How has this exhibit helped you in your investigation of this case?
This exhibit has showed me that a struggle occurred and it also further proves that the perpetrator entered through the back door because they're located next to the back door.
In your expert opinion, what do scuff marks mean in terms of a break-in?
That a struggle may have occurred.
In an exhibit, when we were discussing Exhibit 12, you said the intruder entered through the back of the house?
Yes, that's correct.
Where in the house were the scuff marks located?
Next to the back door.
Did you notice any signs of struggle throughout your investigation?
Yes, as well as the scuff marks, I saw a broken plate that was previously admitted in the open knife drawer.
Have you gathered enough facts and evidence to make a conclusion?
Yes, based on the evidence that I was able to find, I have come to the conclusion that this was a planned burglary gone wrong.
What about this makes it a planned burglary?
Because the
Objection, Your Honor. This is outside the scope of Ms. Kuzak's expertise.
Response?
Your Honor, I'm just asking Ms. Kuzak to explain the foundation for her conclusion of this case throughout the evidence we previously admitted and she explained throughout her testimony.
Overruled.
Thank you. I'll re-ask the question, Ms. Kuzak. What about this made it a planned burglary?
The intruder had no hesitation to enter through the back door when he originally wanted to go through the front door. He went all the way back around the house and then went to the back door.
And what about this planned burglary made it go wrong?
Because at the end of the day, Mr. Brackman was killed with his own knife.
Thank you, Ms. Kuzak. I have no further questions, Your Honor.
Cross-examination.
Yes, Your Honor. And I'd like to repeat again, my name is Alex Aventis, and I'll be conducting the Ms. Kuzak's cross-examination. Now, Ms. Kuzak, I'd like to discuss your conclusions. You dismissed the idea that Mr. Brackman was stabbed from behind while seated. Isn't that correct?
Yes.
Objection, Your Honor. This is beyond the scope. Ms. Kuzak did not discuss that hypothesis throughout her direct examination.
May I respond, Your Honor?
7.
According to the mock trial rules, the scope of cross-examination does not need to be limited to what was discussed on direct examination.
I agree. Overruled. And even if it was limited, I think this is well within the scope.
Thank you, Your Honor. Now, Ms. Kuzak, I'll repeat the question. You dismissed the idea that Mr. Brackman was stabbed from behind while seated, correct?
Yes.
Your reason for this dismissal was that Mr. Brackman would have been alerted via cell phone notification to the intruder's presence, correct?
I believe so.
But Ms. Kuzak, you don't have any evidence to indicate that Mr. Brackman's cell phone was with him at the time of his death, do you?
No.
And you don't have any evidence to indicate that his cell phone notifications were turned on, do you?
No, but I was just hypothesizing based on the evidence that I found.
To your knowledge, nobody from the police department ever attempted to investigate the notification setting on the Ring doorbell app on Mr. Brackman's phone, did they?
To my knowledge, I'm not so sure.
Thank you. I'd like to discuss your theory that Mr. Brackman was stabbed with a knife from his kitchen knife block. The knives in the kitchen knife block are part of a set of J.A. Henkel's knives, correct?
That's correct.
And the block itself and these knives in the block are part of a matching set, aren't they?
That's correct.
But the knife that stabbed Mr. Brackman was a Chicago cutlery knife, wasn't it?
Yes, but are you considering the open knife drawer in Exhibit 7?
Ms. Kuzak, I'm not asking about the open knife drawer at the moment. I'm asking if the knife that stabbed Mr. Brackman was a Chicago cutlery knife, and it sounds like it was. Is that correct?
That's correct.
You would agree with me that J.A. Henkel's knives are more expensive than Chicago cutlery knives, wouldn't you?
I believe so.
Thank you. I'd like to discuss more about these scuff marks. Co-counsel, if you could please share what has already been entered as Exhibit 18. Thank you. Now, Ms. Kuzak, these are the scuff marks on which you partially based your conclusion of a struggle, correct?
That's correct.
You would agree with me that these scuff marks are all approximately the same size, wouldn't you?
Yeah, approximately.
And you'd agree with me that these scuff marks are all relatively evenly spaced, correct?
Kind of, yeah.
Overall, these scuff marks are uniform, aren't they?
Overall.
Now, Ms. Kuzak, thank you, co-counsel, you can stop screen sharing. Your theory is that Mr. Brackman and the intruder were struggling over this knife, correct?
Yes, that's my theory.
And that this struggle caused a plate to be knocked onto the ground and broken, correct?
Yes.
You don't have any other evidence beyond this open knife drawer, the plate, and these uniform scuff marks to indicate a struggle, do you?
Yes.
You have other evidence beyond an open knife drawer, scuff marks, and a plate on the ground to indicate a struggle?
No.
No, thank you. So your conclusion of a struggle is based off of a set of uniform scuff marks and one plate and an open drawer. Is that correct?
That's correct, but also Detective Markowitz saw the chair knocked over. So.
Thank you, Ms. Kuzak. I'm only asking about what you have observed and based your conclusions on.
Okay.
I would now like to discuss your more overall conclusions for this case. You wish you had more physical evidence for this case, isn't that correct?
Yes, but that's correct with almost every single crime.
And there was an absence of evidence in places, wasn't there?
Yes, but that is most of the time in every single crime.
Now, the person captured on the Ring doorbell videos was a person matching the general height and build of the defendant. Isn't that correct?
Yes, that's correct.
But Ms. Kuzx, you don't have any other evidence at all to tie this crime to the defendant, do you?
Yeah, that's correct.
Your Honor, no further questions at this time.
Any redirect?
I have no redirect, Your Honor.
Does the prosecution have any other witnesses?
The prosecution rests their case, Your Honor.
Okay. Is the defense ready to proceed with their case?
The defense calls Avery Becker to the stand. Good morning. Could you please introduce yourself to the jury?
Hello, my name is Avery Becker.
Mr. Becker, why are you here today?
Fortunately, I have been wrongfully accused of a crime that I did not commit.
I'd like to begin by discussing your background a little. Where did you go to high school?
I went to Colorado High School, CHS.
What were the main activities you did in high school?
I did some sports and some other things, but the main thing that I did was mock trial, and it was pretty fun. I got pretty good at it.
How was your time on the mock trial team in general?
At first, I did it to get out of the house, to have something to do, but after a while, it became something that I genuinely enjoyed.
Who else was on the team with you?
Well, my friend Taylor Perkins joined with me. We were very close friends, and there were some other kids there, as well as one named Alex Aventis.
What was your role on the team?
I was a lawyer on our A team. I was really good at crossing closings, and I was especially good at coming up with things on the fly.
Were you always on the A team?
At one point, Coach Frackman bumped me down to the B team. He thought I was lazy and unprepared, and he wanted to separate me and Taylor.
How did you feel about being separated from Taylor?
I was upset. We were really close friends, and it was sad to not be able to hang out with him as much.
Were you ever moved back to the A team?
When I was demoted, Taylor decided it wasn't as fun anymore since we couldn't hang out together. So he decided to quit the team, and that allowed me to be bumped back up.
How was it when you were bumped back up to the A team?
I was really excited, and I got to be on the A team for regionals. And at the regionals, I won Best Attorney Award and Best Closer. So it was really fun for me.
Now, I'd like to move on and discuss your relationship with Coach Frackman. How was your relationship?
Not great, if I'm being honest. We disagreed a lot and had very different methods for getting work done.
What were these different methods?
I was really good at coming up with things on the fly, winging it. But Coach Brackman had all these scripts he wanted us to memorize, and I just felt undervalued and felt it was unnecessary.
How did you feel about Coach Frackman's critiques of you?
I felt they weren't very fair, and I felt that even after I won the awards, he still thought that I didn't deserve them, and that made me upset. I worked hard, and I don't think he understood that, and I don't think he cared as much about that.
Did you ever have any large arguments with Mr. Brackman?
Quite a few times. We argued quite a bit, and at one point I acted out, which I deeply regret.
What did you do, Mr. Becker?
One day we were working at the whiteboard when Mr. Brackman and I started arguing. So I stormed out, but I still had a dry erase marker in my hand.
What happened next?
To explain a little bit, so Coach Brackman had always had this car that he would brag about. It had a license plate that read litigator, but instead of the 8, it was the number 8. So I took the dry erase marker and I wrote Worst Attorney Award on the hood of the car, which I now deeply regret.
I'd like to talk more about this car incident. How did Coach Frackman react to what you did?
When he came outside and he saw what I had done, he got really angry and kicked me off the team. It was at that point that we both realized I had accidentally used a Sharpie instead of a dry erase marker.
How did you feel about being kicked off the team, Mr. Becker?
I was upset. I was sad that was the way mock trial had to end, but at the same time, I really regretted what I did and felt that, it might be just, but I was still really upset and I wanted to get back on the team.
Did you ever go and talk to Mr. Brackman again?
I tried apologizing, and when I went to see him, He said he didn't want to see me.
Did you make any other attempts to talk to him?
I tried texting him, but he never responded. I'm really upset. I can't ever apologize to him now.
Now, I'd like to move on and discuss the day of the day before the crime, March 5th. How did your day begin?
Well, I decided to go to the Fry Shack with my friend Taylor. We also went to the mall, and there were a bunch of other CHS and mock trial kids there.
Who was at the Fry Shack?
I was there with Taylor, as I said before. We were hanging out and playing games on our phones, as well as some mock trial kids, and Alex Aventis was there as well.
What did you do after you went to the Fry Shack?
We walked around at the mall.
Now, I'd like to discuss March 6th, the day Mr. Brackman died. How did your day begin?
I woke up and I realized that I'd lost my phone. So Taylor and I spent the entire day looking for it.
How did you search for your phone?
We tried calling and texting it, and we looked everywhere we had been the day before. But after we couldn't find it and we couldn't hear it ringing, we assumed it was lost or probably stolen.
Now, I'd like to move on and discuss some other high schoolers on who knew Coach Frackman. You previously mentioned Alex Aventis. What was your relationship with Alex Aventis?
It wasn't great. She says we're friends, but we definitely weren't. We worked together, but we never got along.
Why didn't you get along?
Alex always wanted to be the star of the team, and she wanted the Best Attorney Award, which I had won.
Earlier, you heard Ms. Aventis mention texts that you had sent. Did you ever send these texts?
I'd never sent any texts. I don't even know what they say. Plus, if I was going to text anybody, she would be the last person I would have texted. She wouldn't have wanted to help me get back on the team.
Now, I'd like to move on and discuss another student who knew Mr. Brackman. Who is Blair Rollins?
Blair is another kid that goes to CHS, and he's close friends with Alex Aventis.
Do you know anything significant about Mr. Rollins?
We often get confused for each other. We have similar height and build, and he's also disappeared.
What was Mr. Rollins' relationship with Mr. Brackman?
Coach Frackman lost the case that sent Blair's father to jail.
Now, I'd like to finally discuss the accusations. Mr. Becker, you're aware that you are being charged with murder in the first degree and burglary in the second degree.
I am. I still can't believe this is happening.
Mr. Becker, did you partake in any of these actions of which you are accused?
Absolutely not. What happened to Coach Frackman was terrible, and I was upset and could act out at times, but I would never harm him. All I wanted to do was get back on the mock trial team.
Thank you. I have no further questions at this time.
You're on mute, Your Honor.
Thank you. Sorry about that. I got some background noise. So go ahead, Ms. Goldman, cross-examination.
Thank you, Your Honor. You were a senior last year on the Colorado High School mock trial team?
Yes, I was. That is correct.
And you had been on the team for 4 years?
I was on the team for all 4 years, and I got pretty good at it, yes.
And your senior year was the last chance you had to win Best Attorney in the state?
Unfortunately, it was, and I was quite upset that I couldn't, but yes, it was.
You really wanted to win this award at the state level?
I really did, yeah.
Mock trial always came naturally to you?
I was really good at coming up with things on the fly, and so, yeah, it did.
You never worked as hard as your other team members?
I didn't really need to. I was quite good at coming up with things on the fly.
Thank you. Yeah, thank you. You answered my question. This allowed you to get Best Attorney Award at the regional level?
Yeah, I did. I'm quite proud of it.
You and Taylor Perkins were best buds?
We were quite close, yes. Best friends, even.
You and Taylor joined mock trial together?
Yeah, it started out as a way to get out of the house, but quickly became something we enjoyed.
But all you did during the meetings was text each other from across the room?
We did, but it was mostly because I didn't really need to practice as much since I was better at coming up with things on the fly.
And then Mr. Brackman would get mad at you for not paying attention during the meetings?
While I felt I didn't really need to, he did, yes.
You always had high quality cross-examinations and closings.
I'm sorry, you cut out a little bit. Can you repeat that?
I'm sorry. You always had high quality cross-examinations and closings.
I was quite good at it, yeah, and I was good at coming up with things on the fly.
But Mr. Brackman never gave you credit for anything you did.
No, and I felt really undervalued and unappreciated. It made me quite upset.
He insisted that you followed his script.
Unfortunately, yes, though I didn't need to.
However, at the regional competition, you deviated from the script.
I did, yes. I felt that I was better off doing things my own way.
However, Mr. Brackman did not like this.
He didn't like it at all, no. He felt that it was because I was lazy and forgot.
And this is what made you get cut to B team?
Unfortunately, yes.
And by doing this, he also took away your closing?
He did, and I was quite upset about it.
And you didn't want to be on B team?
No, I didn't. I felt the only way that they won was because Coach Frackman wrote all the scripts for them.
And you thought that B team was full of, and I quote, full of losers?
At times, yes, I felt that they weren't as good at it as I was.
After spending so much time on A team at the end of your senior year, you got demoted to B team?
Sadly, yes.
And this took away your last chance to get best attorney at the regional tournament?
Objection, asked and answered. You're muted, Your Honor.
Sorry. I'll sustain it. It has been asked and answered.
Yes, I'll move on. Once you were demoted to B team, you got your best bud Taylor to quit with hopes of being back on the A team?
He wanted to quit himself. He didn't feel like it was fun anymore since we couldn't hang out together.
But still, Taylor quit to benefit you?
He did, yes.
After winning the awards at the regional competition, Mr. Brackman still did not congratulate you?
He thought I was lazy and that I didn't deserve it, which made me upset. So yeah, no, he didn't.
And in front of everyone, he told them that you did not deserve this award?
Yeah, and it made me really upset.
Mr. Brackman claimed that the only reason the team won was because of the other members?
Objection, hearsay.
Response?
Your Honor, according to Rule 801, this is a statement of a party opponent.
Response, Your Honor.
Go ahead.
This is Mr. Brackman is not a party opponent.
Any other reason why this would not be hearsay or should be admissible hearsay, Ms. Goldman?
No, I'll move on, Your Honor. You responded by calling Mr. Brackman the worst coach in the state?
I said it in the heat of the moment, but yes, I said it, though I didn't really mean it.
Thank you. And after your argument with him, you stormed out of the building?
I did, yes. I had a dry erase marker in my hand.
And you went into the parking lot where Mr. Brackman parks?
That is correct, yes.
Mr. Brackman owned a white Porsche?
He does, yes.
And he loved his Porsche?
He would brag about it quite a bit. Yes, I assumed he did.
Once you went into the lot, you wrote Worst Attorney Award on the hood of his beloved Porsche?
Yes, in the heat of the moment, I acted without thinking, and I deeply regret it.
You answered my question, Mr. Becker. And you wrote this in permanent marker?
Though at the time I thought it was a dry erase marker, yes, I did.
Mr. Brackman was angry once he saw his car?
He was, and I even offered to help pay for it, to fix it by getting a summer job. But yes,
you already answered the question. And then he kicked you off the team for good?
He did, yes, and I was quite sad that that was how it had to end.
Which ended your 4-year-long mock trial career?
Sadly, yes, it did.
And this got you even more mad at Mr. Brackman?
I was upset. I couldn't believe this was how it had to end, and I felt that I really wanted to keep going. But so, yes, I was upset.
You lied to your own mother about what happened, though?
I was ashamed of what I did, and I didn't want her to be mad at me. So, yes, I did.
And then you told her you would get back at Brackman if it's the last thing you do?
Oh, yeah.
While I did say that, I had no intention
Thank
of
you.
harming him in any way.
It was a yes or no question, Mr. Becker. On March 6th, the day of the murder, you were with your best bud, Taylor?
Yes, we were looking for my phone, which I had lost.
Taylor, who joined mock trial because of you?
Yeah, we joined together to hang out.
Taylor, who quit mock trial to benefit you?
He wasn't having fun since we couldn't hang out together.
Asked and answered.
And who ditched school because of you on March 6th?
Hold on one moment, Ms. Goldman. We have an objection. The objection was to asked and answered. What? Can you repeat the question? What was the question that was asked and answered, Ms. Marguerite?
Oh, it was once again asking if Taylor Perkins had left the A team for Mr. Becker, which I believe has been asked.
Response?
I have no response, Your Honor.
Within the context of the questioning, overrule.
Thank you. You testified earlier that you were great at mock trial.
I was, yes.
And according to the scores of the judges, you were still a top performer.
Yes, I was.
All you needed to do was smile at each judge and they understood you knew the case.
I felt so at times, yeah.
Thank you. I have no further questions.
Okay. Any redirect?
Yes, Your Honor.
I mean, I do have a brown
Becker,
for this one.
I asked you many questions about what
Well,
you What did you initially say to your mother?
I'm sorry, can you repeat it? I couldn't hear. There was a lot of stuff going on.
Yes. What did you initially say to your mother?
I said that he kicked me off the team for no reason, and I was ashamed, so I didn't tell her the truth.
Why didn't you tell her the full truth?
It's like I said, I was ashamed, and I was really upset with myself, and I didn't want her to be mad at me.
Thank you. I have no further questions at this time.
I don't think that calls for a recross. So, does the defense have further witnesses?
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
Whenever you're ready, counsel.
Thank you, Your Honor. Good morning. Please state your name for the court.
Good morning. My name is Taylor Perkins.
Why are you here today, Mr. Perkins?
I was part of the CHS mock trial team with Avery, and I knew Coach Frackman.
I'd like to discuss your experiences on the mock trial team. Are you still on the team?
Nah, I graduated last year from CHS. Now I'm at CU Boulder.
What was being on the mock trial team like?
It was fun to hang out with friends, and Avery and I had fun time being lawyers.
Did you have any negative experiences on the team?
Not at first, but as time went on with Coach Brackman and Avery, it deteriorated. They didn't always see eye to eye on everything.
What did you think of Mr. Becker and Mr. Brackman's relationship?
Objection, Your Honor. This calls for speculation.
Response?
Yes, Your Honor. This question is merely asking Mr. Perkins to testify to his rationally based perception of what he observed about the relationship between Mr. Becker and Mr. Brackman and how that affected him.
I agree. Overruled, but if he goes beyond that, you're welcome to renew the objection, Ms. Weber.
I'll repeat the question, Mr. Perkins. What did you think of Mr. Becker and Mr. Brackman's relationship?
You know, from afar, these squabbles were kind of funny, but I didn't think much of it until the incident before regionals.
What incident before regionals?
Avery came to practice super unprepared, and in response, Coach Frackman demoted him to the B team.
How did this impact you?
I had a feeling that was just really unjust, and so I tried to help Avery.
How did you try to help him?
I stepped down from the team. Mock trial meant more to him than it ever did to me, and so I had a feeling it was the right thing to do.
How did Mr. Brackman react to that?
He had to let Avery back on the A team, and things calmed down again.
Did things stay calm?
They did for a while, and then the event with the Porsche happened.
I'd like to talk more about this event with the Porsche. What happened?
Well, one day during practice, Avery wrote on Coach's car in permanent marker, even though he thought it was dry erase and it was an accident.
How did Mr. Brackman react to that?
Even though Avery apologized over and over, Coach still wouldn't have any of it, so he kicked Avery off the team.
What happened then?
Well, I thought that it was Avery's fault and it was horrific what happened to Coach's car, but I thought it was Avery's senior year and Avery still deserved to be on the team, so I tried to talk to Coach Brackman.
What did you do when you talked to Coach Brackman?
I asked him if he would let Avery back on the team, but he still wouldn't have any of it, even though Avery felt awful.
What did you do after that?
Well, March 5th after school, Avery went and he tried to apologize in person, but Coach wouldn't even talk to him, so we just left.
Where did you go?
We didn't want to push him, so we just went to the Fry Shack and hung out there.
I'd like to discuss more about when you went to the Fry Shack on March 5th. What is the Fry Shack?
It's this sweet local burger joint, and all the kids from the mock trial team loved it.
Who were you there with?
I was there with Avery at first, but the rest of the team showed up later.
What happened when the other team members showed up?
Almost everyone was actually super kind about the whole matter of Avery getting kicked off.
Why almost everyone? Who wasn't kind about it?
Well, Alex Aventis had this way of being really insincere and not seeming sorry about anything.
What did you think of that?
I thought that the thought of someone disrespecting my friend like that, it made me angry.
And how did Mr. Becker react?
He was really upset and he ran off to the bathroom. I think he left his phone on the table.
What happened when he returned from the bathroom?
We were still pretty upset, so we decided to leave the Fry Shack. Of course, we didn't realize until later that he didn't have his phone. I don't think he ever picked it up off the table.
I'd like to move on and discuss the next day, March 6th. Where were you that day?
Avery and I went on a quest to find his lost phone.
How did you go about looking for the phone?
We spent the whole day retracing our steps. We went in and out of every single store in the mall, and I kept on calling and texting the phone to try to find it, but it just went to voicemail.
What did you do then?
After a couple more calls and texts, I remembered seeing his phone at the table on Fry Shack the day before. So after we finished searching the mall, we decided to head over to the Fry Shack to try to find it.
Did you find it at the Fry Shack?
Nah, we never found it, which was super disappointing because we spent the entire day looking. We got distracted at Fry Shack when some of the people from the team showed up, which was odd.
Why was that odd?
It was during mock trial practice, and they said coach never showed up to practice, so they left.
Why hadn't the coach shown up to practice?
Apparently, he'd been killed, and then Avery got accused, which makes no sense. I was with him the whole day. He couldn't have killed Coach Frackman.
Thank you, Your Honor. No further questions at this time.
Cross-examination, Ms. Weber.
Thank you, Your Honor. Mr. Perkins, you were a senior at Colorado High School last year, correct?
Now I'm at CU Boulder. Go Buffs.
You were on the mock trial team.
Yes, I was on the mock trial team.
You were on the mock trial team with the defendant, Avery Becker.
Yes.
The defendant is your best friend, right?
Yes.
The only reason you were in mock trial was because the defendant was on the team, right?
Yes, we had fun doing it together. We were kind of the dynamic duo.
It's your testimony that the defendant did not try hard enough at mock trial. Is that correct?
He didn't really have to. He was really good at it.
Thank you. You answered my question. It's your testimony that the defendant did not come prepared to mock trial practice, correct?
No, he wasn't always prepared.
And that sometimes the defendant would arrive late to mock trial practice.
Yes.
In fact, just 1 month before the regional tournament, the defendant came to mock trial practice the most unprepared you'd ever seen. Is that right?
Yes, as a response, Coach Brackman demoted him to the B team.
Yeah. You say that he was obviously making things up on the fly, correct?
Yes.
That the defendant was getting off track, right?
Yes.
And despite these actions, you claim the defendant is still A-team material. Is that correct?
As I said, most of the stuff he came up with on the fly was better than Coach Brackman's scripts.
It was after that practice, the practice where the defendant was the most unprepared you'd ever seen. The defendant was demoted to the B team, correct?
Yes.
But just 1 week before regionals, you quit the mock trial team so the defendant could get their spot back. Is that correct?
I'm going to be honest here. I don't even like mock trial that much. And Avery really did. So I had a feeling it was the right thing to do.
So that's a yes. You quit the mock trial team so the defendant could get their spot back?
Yes.
You claim that you quit because the defendant was a senior. It's their last chance to win awards, right?
Yes. And mock trial didn't mean that much to me at all.
It wasn't a hard decision for you to quit mock trial, right?
No, it wasn't.
The defendant and Mr. Brackman, they didn't really get along as far as you could tell, right?
No, they didn't always see that. They didn't always see eye to eye on everything.
The defendant didn't really like Mr. Brackman as far as you could tell. Is that correct?
Objection, Your Honor. This question calls for speculation.
Response?
I'll move on, Your Honor. The defendant and Mr. Brackman were engaged in a feud. Is that correct?
They had squabbles, yes.
And you found their little feud funny, right?
From afar, squabbles can be funny, yeah.
It was after the defendant vandalized Coach Brackman's car that he was kicked off the mock trial team, right?
Yes.
Despite the defendant's irresponsible actions, you believe that it wasn't fair the defendant was kicked off the mock trial team, isn't that correct?
Objection, Your Honor. Asked and answered.
Response? Ms. Weber?
Your Honor, I believe opposing counsel might be frozen.
Okay, we'll give her a minute.
Sorry, I'm back. My computer glitched.
Okay, so what's the response to the asked and answered objection?
Your Honor, this is a separate question. I'm simply asking if in response to being kicked off the team, the defendant felt it was fair for Avery. I have not asked the defendant, or excuse me, I have not asked Mr. Perkins anything about his response.
Overruled.
Thank you. Mr. Perkins, I'll ask the question once again. Despite the defendant's irresponsible actions, you believe it wasn't fair he was kicked off the mock trial team, correct?
No, I don't believe it was fair. It was his senior year, and he was really good at it.
You ditched school with the defendant on March 6, 2020, correct?
That is correct.
It was just you and the defendant?
Yes.
It's your testimony you were looking for the defendant's phone, is that right?
Yes, we went on a quest all over the mall, and then we went to the Fry Shack.
Yeah, and you later remembered you could have just used the iCloud website to locate the cell phone. Is that correct?
I've actually got an Android, so the whole iCloud, find my iPhone.
Thank you. You've answered my question.
All a little bit confusing.
Thank you. You spent an entire day, not at school, but driving around town, the mall, the Fry Shack, looking for a cell phone you could have found with the Google search, right?
As I said, I'm not really good with the whole iPhone, Android. I've got an Android. That works for me. Yeah.
So that's a yes, Mr. Perkins. That's how you spent your day?
Yes.
The defendant had an inflated ego, right?
Well, what can I say? He was the best lawyer on the team.
And the defendant was rash, right?
At times, yes, he could be rash.
Thank you. I have no further questions, Your Honor.
Any redirect, Ms. Abbott?
Yes, Your Honor, a brief redirect. Mr. Perkins, opposing counsel asked you a lot of questions about why you stepped down from the mock trial team. Why did you step down?
I don't really like mock trial, and Avery is a good friend. And so I thought the right thing to do was to step down because he had a lot more fun with it than I did. And I didn't see any point of being on the team if he wasn't there.
Thank you, Your Honor. No further questions.
Okay. I don't think this calls for any recross, but Ms. Weber, did you feel like you wanted to do a recross here?
No, Your Honor.
Okay. All right. Does the defense have further witnesses?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand.
Whenever you're ready.
Good morning. Could you state your name for the court, please?
Good morning. My name is Blake Van Owen.
Tell us why you're here today.
I'm here today to give my expert opinion on the cause of death of Mr. Mackenzie Brackman.
Professor Van Owen, before I get your expert opinion, I want to learn more about your background. What do you do for a living?
I am a private investigator, a professor, and an ex-police officer.
How did you start your career?
As a kid, I was obsessed with crime shows like Law and Order, and so I developed a passion for police work. And so as soon as I graduated college in 2005, I joined the Aurora Police Department.
What did you learn while you were on the police department?
While I was a part of the force, I learned a lot about law enforcement, and I learned a lot about the way that they investigate their cases and the tools that they use to investigate their cases.
How did the police force live up to your expectations?
I really liked the investigative part of it and being able to solve all these cases, but I didn't agree with a lot of their policies. And then about 9 months in 2006, I injured a woman during an arrest while using police department approved tactics. And while I was officially cleared by the department, I never really cleared myself for the incident. And so I left the force.
What did you do after leaving the police force?
I worked for a little bit as a school resource officer and as a private security guard to keep up my skills, but I really missed the investigative part of police work. And so I decided to become a private investigator, and I've been a private investigator ever since.
How has your career changed since then?
In 2015, I obtained a master's degree from Ashford University in criminal justice. And by gaining that education while I was practicing as a private investigator, I became knowledgeable enough about the field to teach a course on police practices at CU Denver.
What specializations have you acquired in your career?
I have testified in court as an expert in crime scene reconstruction 8 times and cell tower data interpretation 5 times in the past.
How do you use your expertise on cases?
On top of my private investigation of the witnesses, I'll look at crime scene reconstruction and cell tower data, and I'll review how they're related to the case.
Finally, how often do you use your expertise?
I'm personally involved in about 9 to 12 cases a year, and overall I've been involved in probably over 100 cases by now. And additionally, I regularly go to conferences to keep myself up to date on the field of police work as it changes over time.
Your Honor, at this time we move to admit Professor Blake Van Owen as an expert in investigation with specializations in interpreting cell tower data and reconstructing crime scenes.
Investigation specialized in cell tower data and crime scene reconstruction?
Doesn't buy it.
Just one moment. Ms. Kumar, any objection or voir dire?
I do have a short voir dire, Your Honor.
Go ahead.
Mr. Van Owens, you were only a cop for a short period of time, correct?
For 9 months, yes.
And in this very short period of time as a cop, you only worked with the Aurora PD?
I was a part of the Aurora Police Department, yes.
So the only police practices that you have firsthand knowledge of are the practices of the Aurora Police Department.
Yes, the 9 months that I spent at the Aurora Police Department.
Yet you still teach a whole course on generalized police policies? Correct.
By gaining my education from Ashford University and practicing as a private investigator, I kept up my skills and knowledge about the field enough so that I could be hired as a professor by CU Denver to teach that course on police practices.
What is your degree from Ashford University
In criminal justice.
And you use their online program to gain this degree, correct?
Yes, I did.
And you have no specific training in investigating cell phone data, right?
Working as part of the police department and as a private investigator, I've looked at these things and I've been able to testify as an expert in cell tower data interpretation in courts in the past.
However, you have no specific training just for cell phone data, right?
Apart from my experience of looking at cell tower data during my time on the police force and as a private investigator, no training other than that.
Or crime scene investigations?
Again, apart from my time as a private investigator and my time on the police force, I don't have any specific training for crime scene reconstruction.
Thank you. Your Honor, I object to the designation of Mr. Van Owen as an expert witness because witnesses must be determined to be actually qualified to opine on the topics they are endorsed for beyond the simple assertion that they are an expert. Mr. Van Owen is offered as an expert witness in cell phone data and crime scene investigations. However, he's had no official specific training in these areas, and I object to the designation of him as an expert witness.
Your Honor, may I respond?
Go ahead, Mr. Ferrer.
Your Honor, in accordance with Rule 702, a witness may be admitted as an expert by knowledge, skill, education, experience, or training. It's not required that they exhibit training among everything else. It's simply one or the other. And in this case, Professor Van Owen displays many of them. Starting with cell tower data, Professor Van Owen testified that on the cases that he works on, he uses cell tower data and interprets it. Beyond that, he's displayed his skill, and his skill has been recognized by various courts 5 different times. And considering the fact that he works 9 to 12 cases per year, he's keeping his skills up. And his career has lasted, or his career began in 2005 and has brought him to where he is today. So as far as cell tower data goes, he has more than enough experience. And crime scene reconstruction is the exact same story. He started this in his time at the police department, where he got the training and the on-the-job experience. Once he moved into private investigation, as he mentioned, he uses crime scene reconstruction as part of his casework, and he has availed himself as an expert in crime scene reconstruction 8 times in court, displaying the skills and how his skills have been recognized under constitutional laws before. Because of this, Professor Van Owen should be admitted as an expert under Rule 702.
I'm inclined to agree. I think to the extent that Ms. Kumar, your objection is well taken, but I think it goes more to the weight rather than whether he should be admitted as an expert. So the court will admit him as an expert in the field of investigation with a specialization in cell phone tower data and crime scene reconstruction.
Yes, Your Honor. Professor Van Owen, I'd like to get back to your expert opinion. What is your expert opinion regarding this case?
My expert opinion is that law enforcement charged the defendant, Mr. Avery Becker, without good enough evidence because they misinterpreted information about the cell tower data, they did not pursue enough witnesses, and they jumped to far too many conclusions about today's case.
What areas of law enforcement's investigation do you believe these flaws are present?
They're blatantly obvious in their crime scene reconstruction, their pursuit of other witnesses, and their interpretation of the cell tower data.
Professor Van Owen, before I move on to the areas you just described, I want to talk more about law enforcement. Which members of law enforcement are working on this case?
They are Detective Markowitz and Ms. Kuzx.
What interactions have you had with Detective Markowitz?
I've worked with Detective Markowitz on a few cases before, and so I'm fairly familiar with her work. And I also reviewed her work for today's case.
What about Ms. Kuzx?
I know Ms. Kuzx professionally because I've been to a number of conferences with her, and I also reviewed her work for today's case.
Professor Van Owen, I'd like to talk about today's case. Law enforcement has already presented their reconstruction of the crime scene. What is your opinion on their reconstruction?
I hardly agree with any part of the prosecution's story. I agree that an intruder entered Brackman's home and then stabbed him in the back, killing him, but I don't agree with any other part.
Why do you not agree with the rest of their reconstruction?
Law enforcement's reconstruction is based on assumptions. They assumed that Mr. Brackman was alerted when an intruder entered his house, and then they assumed there was a struggle that followed in which Mr. Brackman was killed.
Why isn't it fair to assume that Mr. Brackman was alerted to the intruder on his property?
The prosecution is arguing that Mr. Brackman was alerted by a Ring doorbell notification that would have been sent to his phone. But knowing how Ring doorbells work, Mr. Brackman could have not had his notifications enabled and therefore not received one, or he could have just not had his phone on him at the time and not seen the notification for any other reason. And the prosecution has failed to address these issues in their reconstruction.
Moving on to your second point, why can't we conclude that Mackenzie Brackman was killed in the midst of a struggle?
The prosecution is arguing based on some scuff marks by the door, some digital images, and an open slot and a knife block that Mr. Brackman died in a struggle. And none of that evidence is good enough to confirm that there was a struggle.
Why is the evidence inadequate?
This evidence, as I said, is based on assumptions, and they haven't proven that any of this evidence goes towards their theory that Mr. Brackman died in a struggle.
How do you believe these issues impact our interpretation of law enforcement's reconstruction?
Well, these issues tell us that law enforcement's reconstruction is not the only one. There are other possible reconstructions, such as an intruder entered Brackman's residence without alerting Mr. Brackman, and then he stabbed Mr. Brackman in the back while Mr. Brackman was sitting down, and the intruder was standing up when he stabbed Mr. Brackman in the back.
Professor Van Owen, I'd like to move on now to talk about the defendant and the evidence that links the defendant to this case. Detective Markowitz has already testified as to her theory of how cell tower data supports the idea that Mr. Becker traveled from his home to the residence of Mackenzie Brackman. So to start off, I want to ask you, what can you tell the jury about cell tower data?
Cell tower data is nowhere near as accurate as GPS data. The best it can do is tell you when a phone made or received a call or text and what cell tower it connected to do so.
Why isn't cell tower data as accurate as GPS data in determining someone's location?
A cell tower covers a very large area, and when a phone connects to that tower, we just get what area it connected from, not the exact location that it connected from.
Professor Van Owen, I want to look at this in context. Co-counsel, could you please screen share Exhibit 16? Professor Van Owen, what is your opinion on Detective Markowitz's cell tower map?
This map is extremely deceptive and unreliable.
Thank you, co-counsel. Professor Van Owen, why do you believe this map is extremely deceptive and unreliable?
Detective Markowitz made this map, and he made it seem like the cell tower was always, the cell phone was always connected to the closest cell tower at all times. Additionally, she makes it seem like the CDR data she collected can be used as GPS data, and she failed to include any scale or distance marking on this diagram at all.
Professor Van Owen, I want to break that down point by point. First, how does this map make it seem like Mr. Becker's phone was always connected to the nearest tower?
Detective Markowitz highlighted these 3 red sectors on the map and made it seem as if everything in this case happened inside those 3 sectors. But in reality, we don't know that the phone was connected to each of these, that was closest to each of these towers at these times, just that it connected to them.
Moving on to your second point, how does this map confuse GPS data with cell tower data?
Detective Markowitz put 3 different houses on this map and is trying to argue that she can tell that Avery Becker's phone traveled from his house to Mr. Brackman's house along a set path. In reality, we don't know exactly where Mr. Becker's phone was at any of these times, and so it is wildly unfair to assume that his phone traveled along a specific path that's been highlighted in this diagram.
Finally, why does it matter that Detective Markowitz didn't include a scale on this map?
Each cell tower sector can reach out for 6 miles. And we don't know, and so that means that we don't know whether Mr. Becker's phone, where in those 6 miles Mr. Becker's phone was. It could have been anywhere in any of these red sectors or potentially even beyond them.
How can this be illustrated on the map?
If you take a look at cell tower 1227 at the top of the diagram, it states that Mr. Becker's phone pinged this cell tower at 12:47 in the afternoon. All this tells us is that at 12:47 in the afternoon, Mr. Becker's phone could have been anywhere 6 miles in this direction from the cell tower, 6 miles in this direction, 6 miles in this direction, or 6 miles in any direction from this cell tower. And the same goes for these other 2 towers. The only problem is we don't know how far the 6 miles out is because Detective Markowitz failed to include the proper scale or distance marking on this map.
Thank you, co-counsel. You may stop screen sharing the exhibit. Professor Van Owen, in your expert opinion, how effectively was cell tower data used by the law enforcement?
Not effectively at all. They made far too many assumptions about Mr. Becker's location at far too many times.
Finally, in your expert opinion, how important are these oversights to the results of law enforcement's investigation?
They're very important. All of these oversights, assumptions, and conclusions that law enforcement made caused meaningful evidence to be omitted from today's case. And without that meaningful evidence, law enforcement does not have enough evidence to strongly support their story and eliminate all the doubt associated with it.
Thank you, Professor Van Owen. Your Honor, no further questions at this time.
All right, Ms. Kumar, cross-examination.
I do have a brief cross-examination, Your Honor. Mr. Van Owens, in all of the cases you are hired on, you testify for the defense, correct?
In cases like this, the prosecution usually hires their own law enforcement because they don't have to pay extra for a private investigator. So yes, all the cases I've testified before, I've testified on behalf of the defense.
However, you like to think of yourself as a check on the power of the police, right?
Yes, I like to think of myself as I make sure the police department doesn't make these errors such as the ones present in this case, and that true justice is given out.
And you earn a lot of money revealing where the police have dropped the ball, correct?
Each case I'll earn $6,000 to $10,000 per case, depending on the case. And that's just my job. That's what I'm hired to do. And so that's how much I get paid.
On any of the cases you have ever testified on, you have never testified for the prosecution?
Objection, Your Honor. This was asked and answered.
Overruled.
Thank you, Your Honor. Mr. Van Owen, I'll re-ask the question. On any of the cases you have ever testified on, you have never testified for the prosecution?
As I stated before, the prosecution usually hires law enforcement for these types of cases.
Thank you, Mr. Van Owen. That is a perfect answer. And you handle between 9 and 12 cases a year, correct?
Thereabouts, yeah.
And given that you typically charge between $6,000 and $10,000 per case, you would make anywhere between $54,000 and $120,000 per year on these defense cases?
That's how much I get paid. That's what I do to make a living for myself, and that's my job. So yes, that's how much I get paid.
How much are you charging for this particular case?
To date, I've charged about $7,000 for this case.
Thank you, Mr. Van Owens. I will move on to more questions. Just to clarify, you are not actually a law enforcement officer anymore?
Not anymore. I'm a private investigator now.
And throughout your witness statement, you continuously contradict both CSI Kuzx and Detective Markowitz findings concerning the case, correct?
Their findings are based on assumptions and evidence that isn't good enough. So yes, their evidence, I say that in my witness statement, that their story isn't good enough because their evidence doesn't support it.
At one time in your witness statement, you refer to Detective Markowitz as defective Markowitz, correct?
Yes, at the time, yes.
And Detective Markowitz, who is law enforcement, came to the conclusion that Becker's phone communicated with cell towers on a route near Becker's house leading to Brackman's house?
He came to the conclusion that the cell phone connected to towers. Nothing about it being on a specific route.
Thank you,
or
witness.
any.
That was the answer. The call detail records show that Avery Becker's phone did connect with a cell tower in the same area as Brackman's house.
It connected with the cell tower, but it could have been anywhere in a 38 square mile area.
Thank you. No further questions, Your Honor.
Any redirect, Mr. Ferreira?
No redirect, Your Honor.
Okay. Does the defense have any further witnesses?
The defense rests, Your Honor.
Are the parties ready to proceed with closing?
Yes, Your Honor.
All right. And is the prosecution wishing to reserve its time for rebuttal?
Yes, Your Honor.
Okay. Just give me one moment. Whenever you're ready, Ms. Weber.
Thank you. Ladies and gentlemen of the jury, Mackenzie Brackman was murdered in his own home. A knife was plunged into his back and blood splatter stained the hardwood floor. When officers arrived at the scene of the murder, they were greeted by blood spatter, scuff marks, a broken plate, and a chair that had been knocked over. This was a careless and brutal attack. This was a struggle. The worst part, a man's life was brutally brought to an end at the hands of a high school student who was upset about mock trial. A student who displayed a pattern of careless behavior and disregard for others. Ladies and gentlemen of the jury, the burden of proof is upon the prosecution to prove beyond a reasonable doubt the existence of all the elements necessary to constitute murder in the first degree and second-degree burglary of a dwelling. Today, you saw how the defendant texted about a plan to break in and vandalize the victim's home. You saw the defendant approaching the home in gloves and a mask. You heard how the defendant left expensive items behind when he left. You also heard examples of how the defendant was rash, irresponsible, and avoided taking responsibility for his actions at all costs. You saw the route the defendant drove to the victim's home. And ladies and gentlemen, you all saw what unspeakable act the defendant committed. You all saw the dead body lying in his own blood, his own home. When the defendant discovered his mock trial coach was home, did he take responsibility for his actions? No. Instead, the defendant proceeded to violently stab the victim in the back after struggling through the house, breaking plates, knocking a chair over, getting blood spatter on the walls, leaving scuff marks on the floor, and leaving Brackman's dead body in his entryway. You heard from student and mock trial member Alex Aventis, who, unlike the defendant Avery Becker, was dedicated and took her role in mock trial seriously. Alex didn't like how the defendant treated her mock trial peers or coach. Alex observed the defendant's clear hatred towards Mr. Brackman. Alex showed you Exhibit 14, text messages between Alex and the defendant that detailed the defendant's plan to break in and vandalize Mr. Brackman's home. You also heard from Detective Markowitz, an expert in cell phone evidence and call detail records, who used her years of experience to lay out the clear evidence that shows where the defendant was on the day of the murder. She shared Exhibit 16, the call detail records, which shows the defendant at home, then driving to Mr. Brackman's house on Rock Creek Parkway, and at Mr. Brackman's house during the time of the murder. Detective Markowitz also showed you all Exhibit 1 and 3, which show Mr. Brackman's bloody, lifeless body, steps from an open front door, lying in a pool of his own blood with a visible stab wound in his back. Crime scene investigator Kyle Kuzx, an expert in crime scene reconstruction with extensive experience, showed you Exhibit 10, a video of the intruder, the defendant, approaching the front door of Mr. Brackman's house, wearing a mask and gloves. The defendant had a plan. The defendant did not want to be identified, and the defendant did not want to leave any evidence behind. Ms. Kuzx explained that this was a planned burglary that went wrong. Ladies and gentlemen of the jury, you must find Avery Becker guilty on all accounts, murder in the first degree and second degree burglary of a dwelling. Thank you.
Defense close.
Yes, Your Honor. Unanswered, unpursued, unreliable. Ladies and gentlemen, the prosecution just told you that this case is about a high schooler on a mock trial team who was upset. And that's exactly right, but that's all Avery Becker was. In this case, the prosecution has the burden of proof. That means the prosecution must have proven all elements of murder in the first degree and burglary in the second degree beyond a reasonable doubt for a guilty verdict. Reasonable doubt is not overwhelming doubt, but is any doubt that would cause reasonable people to hesitate to act in matters of importance to themselves. Ladies and gentlemen, they have failed to meet this burden. The prosecution's case is riddled with unanswered questions, unreliable evidence, and unpursued suspects. The prosecution would like you to believe this unrealistic narrative, but as a jury, it is your responsibility to maintain an open mind. When you do, all you will find is doubt and misplaced suspicion. On March 6, 2020, Mackenzie Brackman, a local attorney, was found dead in his home after his house had been broken into. Mr. Brackman was known for his criminal defense work and was also a mock trial coach. The prosecution's investigation was flawed from the start when Detective Jordan Markowitz was put on the case and decided to narrow in on the mock trial aspect of Brackman's life, ignoring his criminal defense work, which gave him many enemies. This led Miss Markowitz down a rabbit hole of unreasonable conclusions, following one unreasonable lead, collecting incomplete evidence, and gathering unreliable cell phone data. All this led to the wrongful conviction of Avery Becker, a high schooler on the mock trial team, which Mr. Brackman coached. The first issue the prosecution had was jumping to conclusions. Jordan Markowitz interviewed one person, Alex Aventis, and immediately jumped to the conclusion that this case was related to mock trial. Alex Aventis' arrival of Avery Becker claimed to have texts sent from Mr. Becker, yet when asked to show these texts, she was unable to. Only the next day, you heard she sent screenshots of these unauthenticated texts. Jordan Markowitz decided to rely on these texts and continue down this rabbit hole. Markowitz ignored all other possibilities with individuals such as Blair Rollins. Mr. Brackman had lost the case that sent Blair Rollins' father to jail, a possible motive for Mr. Rollins, yet Detective Markowitz didn't even bother to look into this suspect. The second issue the prosecution had was making assumptions. You heard Detective Kuzx and how she assumed that this was a struggle, but she makes these assumptions off of limited physical evidence and fails to recognize possible alternatives. Ms. Kuzx bases her findings off the flawed ideas that Markowitz had previously set for her. Meanwhile, you heard our expert, Detective Blake Van Owen, perfectly illustrate how this was a sloppy and rushed investigation, with assumptions about the path, assumptions about the break-in, assumptions about the weapon that was used, and assumptions about the Ring doorbell videos. It's clear that all the prosecution has is assumptions. Last, the third problem the prosecution has is an unrealistic narrative. Not every student likes their teacher, and it's clear that Coach Frackman and Avery Becker didn't get along. But the prosecution is attempting to equate disagreements within a mock trial team to murder in the first degree and burglary in the second degree. The day of the crime, Avery Becker and Taylor Perkins drove around town searching for Avery Becker's lost phone, as phone records would indicate. The prosecution is attempting to take this information and make it seem as though Avery Becker was in the vicinity of the crime. But if you look at the evidence, it is clear that he was not. And with Taylor Perkins as an alibi, it is clear that Mr. Becker was nowhere near this crime. The prosecution left so many questions unanswered without regard for the evidence to reach a conclusion that they had predetermined. They determined Avery Becker was guilty before he was proven innocent. In this case, the prosecution has the burden of proof. That means the prosecution must have proven all elements of murder in the first degree and burglary in the second degree beyond a reasonable doubt for a guilty verdict. Ladies and gentlemen, the prosecution has failed to meet this burden. The prosecution's story is riddled with unanswered questions, unpursued suspects, and unreliable evidence. Don't let the prosecution convince you of a wrongful conviction. You can only return one verdict. Declare Avery Becker not guilty. Thank you.
Ms. Weber, rebuttal, please.
Thank you, Your Honor. Ladies and gentlemen, Blake Van Owen reviewed the case after Detective Markowitz and CSI Kuzx went through it. Mr. Van Owen only testifies for the defense. He was going into the investigation looking for an entirely different conclusion, a conclusion separate from the truth, a conclusion that the defense relies heavily on. The defense talks about unpursued suspects, but Detective Markowitz only interviewed one witness because there was already enough clear evidence that pointed to Avery Becker being responsible for this crime. There was motive and opportunity for the defendant to have committed this crime from the very first interview that Detective Markowitz conducted. The defendant himself told you how after he was kicked off the mock trial, he was ashamed, upset. He thought Mr. Brackman kicked him off the mock trial team for no reason. And he went home and told his own mother that he would get back at Mr. Brackman if it's the last thing he did. You want to talk about unreliable conclusions? There's no proof that Blair Rollins is tied to any of this. None of the defense's witnesses are close enough with Blair or have specific knowledge of his habits and character. There's no notable history between Blair and Mr. Brackman other than speculation from witnesses. And Alex himself denied working with or even being closely familiar with Blair. Alex had no reason to lie. They claim that Alex had rage towards the defendant, Avery Becker. However, Alex liked the defendant. You can't have a one-sided rivalry. The defense wants you to believe their wild conspiracy theories. Don't let them convince you. The facts of this case speak for themselves. The defendant is the only person with evidence
that is time, Ms. Weber.
Thank you.
All right, thanks everybody. Before we get to comments, I, if I'm remembering right, Mr. Maris was asking us to get scores in as soon as we can. So if everybody can just let me know when we've got that done.
I'm done.
Okay.
I'm done.
Great. All right, then let's do some quick comments then. Why don't we just go in order of how we show up in the Zoom? So I think that would be Shauna first.
Thanks. You guys, I want to tell you all you did a great job. This is such a weird year, and I know for us as attorneys who appear in court every day, watching yourself on Zoom and doing this over Zoom and without having your team around you, you're showing a lot of courage. And I'll tell you, I've been litigating for 20 years and I would hate this on the camera. So great job. I want to tell both teams, you did a really good job of picking a theme and sticking with it. The defense, I noticed you stayed with it from opening to closing, which was awesome. I would encourage you to keep doing it with your witnesses. I noticed it in the in the direct of your expert, but keep pulling it out and also use it when you're doing the other side's witnesses. Same with the prosecution. You picked up on the careless and the themes, and this is the only person with a motive. One thing when I was a prosecutor that I was taught is find your bad facts, know your bad facts, and get them out. Get them before that jury, and you deal with them rather than letting the other side hammer you with them. If you take some of the sting away, they can't hurt you with it. So I think you all did a phenomenal job. I think this is something that mock trial alludes to. Be careful with interrupting. I know you want to stop and control the witness. If you're going to do it, always thank you. Don't tell somebody it's a great answer. Don't tell somebody that's exactly what I'm looking for. Just say, okay, thank you, and take control back. But I think that that's just part of this dynamic. But you all did a phenomenal job, and I'm really proud of you. Great work.
Yeah, I would agree completely. I'm gonna try to not, to the extent that someone has already said what I said, I was gonna say, I'll just go to some other things that I noticed. I was really impressed with everybody's witness management and their knowledge of the rules of evidence. I would encourage you to not back down so quickly sometimes. If you're not sure, and I get that the rules of evidence are complicated. I did mock trial in law school and people still had no idea what hearsay was. I mean, some practicing attorneys don't know. But that doesn't stop you from just saying it's not hearsay or it's not speculation. You can just answer that and see if it, sticks to the wall instead of just saying, because in some of the cases of these objections, it wasn't. So just give it a shot. It's better than saying, oh, I'll just move on, because you never know if the judge is gonna, give the judge a chance to rule in your favor. The other thing that I think is some actionable advice that, because in your future rounds that you can use, try to really listen to what the witnesses are saying. And when they use like a good line that matters to you, just write it down and save it for later. You can use it in your cross, you can use it in your closing, but like I noticed a couple things that witnesses were saying that kind of could be used against them, about like, you know, I would never jump to these sort of conclusions, but then that's what that person did. So I think as you're working to take it to the next level, which I think everybody in here is well on their way to doing that, that's something that you can look to incorporate. You don't have to, you know, be so preoccupied with it that you're gonna, you know, lose your place. Just pick one thing. You don't have to get every single thing they say, but if you pick one and work it into your close or work it into your cross, it's something that's going to come across for the judges for sure. That was it for me.
I think we have different orders showing up on our various screens. So who's next on your screen?
Oh, I think it's you, Ms. Kerrigan.
Okay, thanks. I have a lot of the similar comments, and I'm not going to repeat them. I guess one thing that hasn't been said is it's better to refer to people by their titles. So detective so-and-so, not Ms. so-and-so. It can come across, even if they're opposing to you, as sort of demeaning and disrespectful. I am also a former prosecutor and judge, and I can tell you in my 35 plus years of practice, I have seen many trials in which the attorneys were not as competent as all of you. And you should be applauded for that. You did a really good job. I think you did a great job handling the hurdles of technology and good professionalism. There were a few interruptions. One thing I would say, when you are doing cross and you ask a yes or no question and they answer with a narrative, I would always go, so that's a yes, right? You know, instead of saying, oh, that's the answer I want, you know, just, oh, so your answer is yes, and then just move on. And I think there was a point where one side helped the other in putting up an exhibit, and that's a great show of professionalism. That will impress your judges and juries remarkably. I guess I felt like maybe there should have been a little more stress on there was really good stress again in opening and closing on the lack of investigation and not even interviewing anybody else on the mock trial team in the opening and closing. But I thought with your expert, maybe pull more of that out. Then it's a little more important to me than the cell phone towers. But that's my only other thing. And great. Yeah, really impressive.
All right. I guess I'll be going last. So you guys have covered quite a bit. So I don't want to touch on what's already been covered. One thing I do want to mention is you guys did use legal terms in closing and in opening. Explain that and use the problem is you've got to look at your jury as they're laymen. They don't know the law. So explain it to them, give them, what is the burden of proof? What does that mean? If you can put that out and lay that out and then tell them what their duty is, what their job is, when they're going to go back and they're going to make this decision in the jury room, what are they seeing? What are the elements of the case? What is it that they need? What needs to be proven in this trial? And what is it that they're going to have to show? So you've mentioned those things throughout opening and closing, but make sure that you actually explain what that means. Other things, going between the different questions, leading questions or on direct or in cross, you can make comments to kind of create a storyline. You know, having question after question after question can get a little repetitive. So create a story, maybe even try to block things out. So, okay, now we're moving on to this part of the story, and you can use that in your opening and closing as well. But overall, yeah, you guys did great with this technology being on Zoom. this is such an odd situation. Normally, you can talk about moving in the courtroom, you can talk about, and having reactions. I mean, that's what the courtroom's about. You guys did great. The witnesses they had reactions even in the Zoom setting. So I think you guys did a wonderful job, and this is a lot of fun to see you all doing this. So thank you guys.
Okay, so I am just waiting to hear from Kyle to see if we are clear to clear, which I think is what I'm supposed to do. So I just texted him just to make sure. I'm just filling in. I was not supposed to be presiding today. I've done it before for our mock trial in law school, but definitely not in the real setting.
And you did a really good job. We were talking a little before everybody else got on, and he was like, oh no. I'm glad I didn't have to do it, that's for sure.
Yeah, I don't think that in terms of like evidence management and with all this technical stuff,
yeah,
I couldn't have the screen sharing thing or whatever. I would have been like that lawyer who had the cat screen filter on. Well, while we're waiting for that, I think one thing that was mentioned about witness control was, I think, really important, because I think in the competitions especially, you get a lot of witnesses that they're going to give narrative responses. You can, between questions, apart from just saying, so that was a yes or so that was a no, you can, between questions, tell them, I'm going to ask you yes or no questions, and you are going to give yes or no answers. Can you do that? But I wouldn't do that like at the first time. But if they keep doing it and you're like, all right, come on. Then at that point, if the witness keeps doing it, it reflects more on them than it does on you.
Yeah.
One other thing I would say that I forgot to say while we're here is, whichever side you're on, if you have the defendant ever on the stand, ever, do not ask them, did they do it? If you're the prosecution cross-examining a defendant, you're telling them they did do it and you're cornering them. If you're the defense attorney and your defendant is on that stand, you need that defendant to unequivocally say they didn't do it. So just fold that in if the defendant's going to testify, which is rare.
Well, and I think the defense asked, you didn't interview my client, right? And then opened the door for them to say your client lawyered up.
Right.
They couldn't have said that if it wasn't for that question. So, because that's inadmissible. I know we're supposed to start the next one at 11, right?
One thing also I want to mention, you guys did a really good job with experts, because that can get very tricky, and it is hard. It's very difficult to get an expert testimony. So knowing the rules, knowing the rules beyond on expert testimony can be huge. And anticipating, when you're planning, when you're doing your outline or going through, anticipating what objections may be coming, and moving on from objections as well. If you don't get that, if you don't have an answer and you just can't get it in for whatever reason, being able to move on, you guys did a great job on that as well. Staying calm, saying, okay, we'll just move on. I'll figure out how I'm going to go forward, even though I didn't get in that particular question or an answer that I wanted.
Okay, we are good to go.
Okay.
Thanks, everybody. Good luck in further rounds.
Yep.
Thank you so much.
Thank you, Your Honor.
Thank you so much, Your Honor.